everyone's permission, let me call us to order since it appears we've hit the quorum. We'll verify that here in just a moment by calling the roll. I first want to thank everybody for making time for this special called meeting this afternoon, and have enjoyed the banter back and forth as we've come on, and most of all hope everyone is safe and well. It's really good to see everybody. Some of you have heard this coming on, but if you notice a couple or three new faces, one of them, of course, is our General Counsel, Brian Lapps, whom we welcome once again, and we'll be hearing from him again, obviously. And in addition, we have our new faculty and our new student regents with us today. The governor has appointed Wanda Lee as the non-voting faculty regent, and Will McElroy as our student regent for this coming year. Wanda teaches at our TCAT at Crossville. She has had a distinguished career in state government as well. She's been with us for about 5 years in administrative office technology, where she's specializing in teaching around recreation, hospitality, and tourism, which I asked her the other day, what were the challenges in that field right now, of course. But she said they are going strong at the TCAT Crossville. Originally from Morristown, it's good to note that Wanda started her higher education career with our system at Walters State Community College. So Wanda, welcome. Do you want to tell us a little bit more about you?
Thank you. I'm really excited to be part of this and to represent the TCATs. I find it a challenge, an exciting challenge, and I look forward to learning a lot. And meeting all of y'all. Hopefully in the soon future we can meet face to face, but until then we'll just do the best that we can.
So thank you and welcome. So if you guys get a chance, give her a call. She's full of energy and understands the role and is excited to present that faculty perspective. So welcome again. To Will McElroy, a student at Chattanooga State Community College. Mass communications major. We may call on him from time to time to be of assistance to us, as he is currently the parliamentarian for the Student Government Association at Chattanooga State, which is most impressive. And he has also served as a delegate to the Tennessee Intercollegiate State Legislature. So William is a man of many talents, and we welcome you as well. And Will, tell us a little bit more about you, please, sir.
Oh, yes. Thank you for that great introduction. I'm going into my 5th semester at Chattanooga State. It'll sadly be my last semester, but I look forward to transferring and seeing what's in store with that. And I'm extremely excited to see what this year holds as we start out online and hopefully transfer over to in-person meetings and work together to help the Tennessee Board of Regents institutions.
Absolutely. No, we're delighted. And you wear such an important hat, giving us that student perspective. So this board will rely heavily on your views as well. What you mentioned you were transferring. What are you thinking for next steps, just out of curiosity?
It's looking like it'll be the University of Tennessee at Chattanooga.
Okay, very good.
So not far from home, and can kind of keep in touch with the Chattanooga State people as well.
Excellent. That is a great choice. So excellent news. Today's special called meeting, as you all know, because I understand everybody's done a lot of homework in reading these policy revisions. And of course, we are in a timely situation to make decisions on these. These, of course, are the required federal revised Title IX regulations. And then we also have a new policy to consider today on infectious diseases. This meeting is also being video streamed as we speak, so we are on our live stream. I anticipate that we have campuses, perhaps some media and other interested parties observing this first portion with us. So with that, let me pause. And Sanja, let's make it official if you would call the roll, please, ma'am.
Thank you, Madam Chair. Governor Lee. Regent Apple.
Here.
Regent Burdine.
Here.
Regent Duckett. I see you. Wave your hand, Regent Duckett. Regent Gill. Regent Goldsmith.
Here.
Regent Green.
Here.
Regent Hatch.
Here.
Commissioner Hatcher. Regent Kraus.
Here.
Oh, thank you. Regent McEllier.
Here.
Regent Prescott.
Here.
Regent Reed.
Here.
Vice Chair Reynolds.
Here.
Commissioner Schwinn. Regent Shockey.
Here.
Regent Varlin. I know she's here.
She must be muted.
Yeah.
She's writing a grant.
Regent Womp. Regent Womp.
Here.
Thank
Yes,
you.
Reed.
All right. Good to have you. Regent White.
Here. Excuse me, here.
Thank you. Madam Chair, you have a quorum.
That is excellent. Thank you. And Will and Regent Goldsmith, have you two met on Chattanooga State's campus yet by chance?
I don't believe we have.
Okay. So hopefully at some point you two can connect and compare notes too. So that's excellent. Two good representatives from Chattanooga State this year. So very good. Very good. Before we get into the two agenda items, I'd like to call on the Chancellor for just a moment because obviously we're still in the process of working on fall enrollment. So we don't have hard and fast numbers yet, but I thought while we were all together, Chancellor, with your permission, if you just give us a snapshot of what we're looking like right now on admissions and anything else you might care to briefly update us on.
Absolutely. Thank you, Chairman Reynolds. What I'd like to spend one moment to also just publicly thanking all of the members of our staff at the Tennessee Board of Regents. Every single individual that works at the board office has been going above and beyond every single day since we started the COVID journey together in March. And I really cannot say that enough about how hard they are working and to brag on them publicly about the great job that they're doing. I feel like if we are fighting a battle, I would go to war with these individuals any single day because they have made an incredible army. The results of that, part of it, is you have before you now the fall 2020 semester plan. This is to give you a feel for what all of the colleges are planning for their fall term, and this is the latest update on the chart. If you will notice, the far left side has the community colleges listed, and most of them, for the majority of their programming, is going to be online and remote education with some hybrid courses there as well. The majority of our community colleges, the programs that they teach lend themselves well to this, so that is what they have planned for the fall. And when people say, when are you starting back? I very quickly say to them, well, we never shut down. Our colleges really didn't miss a beat. They kept students going. We graduated our spring class. We started our summer term, and we will start our fall term just as we would, only in a different modality. For our technical colleges, when you look at the chart, you can see that the majority of them are planning to have mostly in-person instruction with some hybrid classes that will be going on, and also with the realization that they are ready in fall term to go completely online in the event we have another major outbreak and we have to shut down again. When you look at the far right side of this chart, what it tells you is when they will begin the semesters, in the semesters, and whether or not they plan to have an end date prior to that Thanksgiving date. We talked a lot with the colleges about the possibility that once students go out for Thanksgiving, the exposure level goes up. And so if we have ways to mitigate that and do mostly online after Thanksgiving, that's what's reflected in this chart. To talk about enrollment numbers, again, we are still at counting application stage. For our technical colleges, we are a little bit ahead of applications from last year, which is good news. For our community colleges, we are still behind. We're about 17% behind where we were this time last year, but that's much improved over our end of May numbers, which was 24% behind. We have been working diligently through all avenues trying to increase enrollment. TBR has been very aggressive in their marketing. I know many of you have seen the marketing outreach that we've been doing and have commented favorably on that. We've also been working with the post-secondary transition task force that was set up. This group involves people from DOE, THEC, UT, TACUA, and the TBR colleges. The AIRS Foundation and Tennessee Achieves has also been working with this group to try to make sure that we are working with every high school graduating class possible, that they know now is not a good time to take a gap year, and we're here for them. The fall 2020 numbers for enrollment, we will have a better handle on that after August the 14th, which is our 10-day prior to start of class time. So we'll be prepared to give you a total update at the September 22nd, 23rd meeting. So, Madam Chair, that's just a quick update on where we are with enrollment and our numbers. Do I have any questions from anyone on that?
Thank you.
No, thank you. That's a very good snapshot. And again, our profound thanks to your team. And at the end of the day, you're the general. So we start by thanking you for keeping us on the right track and closing these numbers for the fall to the best of our ability. Excellent report. Thank you.
Thank you.
So, and more to come in the next month or so. So, Mike Krause, if you're still on, from your perspective where you sit as the head of THEC, any comments in response to the Chancellor's report?
Well, first, just to echo her gratitude to the campuses, but also just to reflect from THEC, we've seen the absolutely intense work that Chancellor Tidings and the central office staff have been doing to both get ready for fall, but to the Chancellor's point, you know, TCAP and community colleges never closed, right? They adapted. What I think we've all got to be prepared for is that August 24th, when classes officially begin for our new freshman class, I think we have done everything a state can do. We have tested the campuses as with a real-time tabletop exercise with Chancellor Tidings. We have provided testing availability when requested, and we've got a foundational set of operating principles in the governor's Pledge for Higher Education, Tennessee Pledge for Higher Education. I think all of those things taken together as a constellation, we have done everything we can to pursue our most important goal, which is the safety of our students, faculty, and staff. And so we look forward to a semester that, while it will look different, and I think it's very appropriate for all of us on the board to brace ourselves. The instructional environment does look different, but it should in response to this threat. I think we also can't lose sight of the fact that what's going on at TBR campuses right now, more important than ever. Because economic opportunity is at the core, as Chancellor Tidings likes to say about the mission, is workforce development and student success. Workforce development right now in the current economic environment is absolutely essential to our state's economic recovery. And on the more individual level, it's important to these students' ability to go get a great job. And that mission can't stop. It can't stop because of a pandemic. And that's why I think, I know Chancellor Tidings and her team have been working so hard. So we're going to go in confident and optimistic. And we're going to ask our students, our student regents that are on the day, a lot of this semester's outcome rests with our students and their willingness to comply with the things that we know work, specifically around mask wear. I think they're going to. I have great trust in our students. I think they care about their campuses. I think they care about their faculty members. And we're really trying at THEC to go into this semester, while it is going to be one that we've probably never seen before, to go in very optimistic and to go in knowing that at the end of this, we're going to have continued to really propel our state forward. But again, Chancellor Tidings and the TBR team have been national exemplars of how you continue to deliver instruction in some really demanding circumstances.
All of that was beautifully said. Thank you. Thank you very much. So thanks for being on with us today. So, and that was extremely helpful to the board. it's also nice to be part of a constellation. I love your choice of words. So that was fun to hear. Thank you, Mike Krause. You do a great job for all of us as well, and are a true public servant. We appreciate you. Let's turn to our business items then today, if we might, and that's the review and consideration of policy revisions that are required by revised Title IX regulations. Unless anyone has an objection along the way, I'd like to propose that we address, I think there's 5 of these, address all 5 of them together. You are obviously welcome to ask questions of our general counsel along the way, but then we will act on them as a group following Brian's presentation. Does that meet with everybody's approval? A little nod there would be good. Thumbs up. I like that. Thank you. So with that, Brian, once again, welcome to the team. As you said, it is a strange time to have started a new job, but we are grateful that you took the leap with us and you got right to work with these big Title IX revisions. So thank you. The floor is yours.
Well, thank you, Vice Chair Reynolds. I appreciate the kind words and the opportunity to address the board with these issues. As you said, there are 5 policies on the agenda. The primary policy revisions relate to the sexual misconduct policy. The others are more conforming changes and minor revisions. And I'll go through those later, but I'll start with the sexual misconduct policy, which, as you said, is really driven by revisions to the Title IX regulations that were announced on May 6th and go into effect in 2 days on August 14. There continues to be pending litigation seeking to either delay the implementation of these or to enjoin them and prevent them from being implemented. Only one of the courts that I'm aware of has ruled as of this current time, and that's the Southern District of New York, has denied the Attorney General of New York's motion for a preliminary injunction. So we'll see what happens in Maryland, DC, and I think California, where those courts still have to rule. But we're prepared to go forward, assuming this board approves the changes and comply. And then if there are any injunctions, and if those injunctions affect us here in Tennessee, we will figure out what to do based on what the controlling authority is. But in speaking in broad brushes in terms of the major changes of the regulations and the approach, it really, I think, can be summarized into what I've kind of narrowed down into four topics. Is one, there's a great deal more separation of roles in the people involved, and I'll get into that more detail as I go through the proposed revision to the sexual misconduct policy and how we'll interact with our other anti-discrimination policies and procedures. Second, there are detailed procedural requirements for filing complaints, conducting investigations, and adjudicating allegations of sexual harassment as defined by Title IX. Perhaps the biggest revision, and certainly one of the most controversial, is that live hearings are required to make findings of fact and determinations as to whether somebody violated the sexual misconduct policy. And that's going to present challenges for all colleges and universities, including our colleges. And then there are overall narrower definitions as to what is covered by these Title IX regulations. As far as practical effects are on our institutions, these probably won't be as profound as at other colleges and universities, and that's largely because of our non-residential model. In the last 10 years, we've gone back and looked at the Title IX reports that have been filed for the last 2 fiscal years for which data is available, not yet available for 2019, 2020. It appears there probably would have been about 10 cases that meet the definition of sexual harassment under the regulations. All of those were at the community colleges. None were at any of the TCATs. It was 5 in each of the fiscal years. And that's not to say that all 10 would have gone through the process. Some of them likely would have reached some kind of informal resolution. But getting into a little bit more in the specifics now, as I mentioned, the overall definition of sexual harassment is changed, and it's, when combined with some of the procedural requirements, narrower in scope. So what the regulations provide and what we are proposing to do with respect to the sexual misconduct policy is to define sexual misconduct consistent with the sexual harassment and the regulations, which would be to include three separate prongs. That is quid pro quo sexual harassment, this for that, where an employee conditions a benefit or a detriment on refusal to, or on agreeing to or refusing to agree to any sexual requests, kind of the sleep with me if you want a good grade type of thing. Then harassment that is severe and pervasive. At first blush, this seems familiar to what many of you understand as far as Title VII sexual harassment goes from your careers and from your workplaces, but it's a little different in that the conjunction "and" is very important, because it must be both severe and pervasive. Pervasive meaning it generally has to happen more than one time when you're dealing with sexual harassment that does not meet the third prong, which is what's already in federal legislation and already in our sexual misconduct policy, which is sexual assault, and that includes different kinds of sexual assault, such as a rape, but also fondling, which is generally touching for the benefit for sexual gratification. So certain groping, hugging, those types of things would meet the definition of fondling. Stalking, two or more occasions of a sexual nature where somebody is harassing basically somebody else, meets the definition, as well as domestic violence and dating violence. So all of those things now constitute sexual harassment. But to go and to fall under the regs, and thus to fall within the scope of our policy, there are also some limitations. And this is what you may have read about in the paper and you've seen in the proposed policy, is what's getting some other criticism, is that the sexual misconduct must occur in the education program or activity, meaning that the college must have sufficient control over both the setting in which it occurs and the respondent. Because we don't have residence halls, some of the actions that lead to these types of actions happens on Friday nights, Saturday nights, and whatnot. If it happens in an off-campus apartment away from our campuses, it's probably not within our educational program and activity. And that's not going to mean it's going to be totally ignored. It just won't go under this more formal process. And next is that a formal complaint can be filed only by either the Title IX coordinator or somebody who's participating in or attempting to participate in an educational program or activity. What that will mean is that former students, former employees won't be able to file formal complaints and proceed under what the revised sexual misconduct policy is seeking to install. Again, that doesn't mean if we get an allegation by a student or a former employee against a current employee or even a current student, it's going to be totally ignored. It just means it won't go through this more formal process. There was really only one significant business decision, and that was whether to revamp the entire processes or to make the least disruptive changes possible. The staff here opted for the latter, partially on the theory, if it's not broken, don't fix it. And the second was there's limited time to comply with these regulations in a COVID type of environment would make that even more difficult. We will be this fall. We have scheduled to be revisiting our equity, equal employment opportunity, anti-harassment, civil rights policies on a more holistic matter. And this will fall within that. So that will be part of the review. So it may be coming before you again in the winter or spring, as well as we're going to be looking to make some changes to the formal rules that if approved by the board, would then go forward to state officials, including the Attorney General, the Government Operations Committee, as well as others, to more formalize some of the particularly student-related processes. So again, that would be probably in the winter or the spring after the September board meeting. Haven't fully worked out timing of when it would likely to come before you. But the net effect of the regulations is in the revised sexual misconduct policy to comply with the regulation is if the matters don't meet the definition of Title IX sexual harassment, which we've identified as sexual misconduct, and the criteria for filing a formal complaint, we will continue to address them in accordance with our existing policies and procedures that prohibit harassment. And if they meet the new definitions, they'll go through the new definitions. With respect to employees, recognizing that we have to comply with both Title VII and Title IX, employees may have the option of going through the existing policy, even if it would meet both a Title IX sexual harassment definition if proven, and also a Title VII definition if proven. But running through the major changes in effect, and as the Vice Chair said, if you have questions, feel free to raise your hand, interrupt. I'll pause at the end of the policy to ask for any questions overall, though. One of the biggest things and biggest changes in the regulations is separation of functions. Under our current policies and practices, generally speaking, the person who receives a complaint of sexual harassment, who investigates the sexual harassment complaint, and who makes findings of fact in a proposed resolution is going to be the Title IX coordinator. That's no longer permitted under the new regulations. Rather, they're going to need to be at least 3 people, and when there's an appeal, 4 people involved. So instead of usually the Title IX coordinator making a recommendation to the president, who then issues a determination and can then listen to an appeal of the matter, the Title IX coordinator will essentially be the person who does the intake. He or she will receive the complaint, provide supportive measures, get the trains running down the correct tracks. Does it go down the sexual misconduct route, or does it go down the existing route for harassment complaints, and tries to keep the trains running on time, tries to keep them from being derailed. The Title IX coordinator will pass the matter off then, if it meets the definitions of a formal complaint, to the investigator, who will investigate the facts, much like the investigators do now, which is talking to witnesses, reviewing documents, evaluating the other evidence, and then the investigator will prepare a report. The difference is that the investigator will not be making the findings of credibility or findings on whether or not the sexual misconduct policy was violated or any recommendations. That rather will be done by the decision maker. The investigator is charged with making an objective report that will then be presented to the decision maker in a live hearing. The decision maker in that live hearing will listen to the witnesses, ask the questions, and decide the case. This is a little bit of a different, well, it's actually a much different process than what we've got now, and I'll get into the live hearing component of it a little bit later. The appellate reviewer then is going to be a different person. That will be the person who decides the appeal, and the policy has the president of the college being the person who decides the appeal. Especially for the TCATs and smaller institutions, as you probably noticed, and I know some of you have identified, this is going to present an issue of just, do we have enough people who are appropriately trained and able to do that? We're in the process of establishing regional consortiums to do this. So, for example, the investigator and decision maker may come from a different institution. The Title IX coordinator will typically be the Title IX coordinator at the institution in question, and then the appellate reviewer will be the president from the institution in question. But we're probably going to need to borrow people from other institutions. So that model is being set up, and we're in the process of obtaining training and getting our folks trained so that they can do that. Another practical effect is that many of the, in the ability to file a formal complaint, is that many allegations of sexual harassment in just either the colloquial term sexual harassment or the Title VII term sexual harassment don't meet the definition of Title IX sexual harassment. And many of them won't occur within our education programs and activities, either because the complainant is not enrolled or seeking to enroll, or because it's just outside the context of what we do. So the Title IX coordinator will have to make those decisions after receiving advice from the Office of General Counsel on that. Another big change is that formal complaints must be in writing. So no longer can people make anonymous complaints and go through this new process, but rather they must put their complaint in writing, and one can only file on behalf of oneself unless the Title IX coordinator decides to move forward with that. Again, if we receive out anonymous allegations, we're going to try to address them to the extent we can in accordance with the other policies, but it would not go under this more formal policy. As I said, with respect to the investigations, the report summarizes the evidence. It does not make findings of fact. It does provide more procedure involved in that there's a greater ability to evaluate evidence and to review draft reports before they're finalized. Current policy, allows the Title IX coordinator the ability to provide the draft reports, but it become required in these. The live hearings, though, are probably the most difficult thing to handle. Under our policy as it currently exists, and under the new policy, the college has the burden of gathering the evidence. In other words, we don't put it on the student or the complainant respondent, whether they're students or employees, to go out and prove their case or to prove their innocence. Certainly those individuals are allowed to and encouraged to provide evidence that can be evaluated, but it's not their job to establish whether a violation took place. That's the college's job, and that's going to fall on the decision maker, who, under the process, will evaluate what the investigative report has to say. Typically, the investigator will be a witness as to explain what happened, and then the parties will get a chance to provide their input, and then other witnesses will provide their input. There is also the component for cross-examination in the live hearing process. So this process is a little bit legalistic and court-like in that it provides for cross-examination, but at another level, it's not like a lawsuit or even an arbitration like you may have participated in or seen on TV, just because the role of the advisor, which can be a lawyer if somebody wants to bring one, is limited to the cross-examination. So it's really going to be controlled by the decision maker, and it's going to be on us to train the decision makers to make sure they ask the right questions, to make sure that they can control the hearing, and to make sure that they have the information necessary to determine whether a preponderance of the evidence establishes that sexual harassment, sexual misconduct took place. So again, this is a major departure from the current process. Included in that, as I mentioned, cross-examination has to be done by advisors. Parties are never allowed to cross-examine each other. What this means is that if a party wants to bring an advisor of their choice, a lawyer, a mother, father, sister, brother, whoever, that person can do so. If somebody does not have an advisor, though, the college is required to provide an advisor for that person. So we're also going to have to either train up, and again, this is the idea of having that regional model to do it as an advisor, but the policy leaves the flexibility to hire somebody outside to be an advisor if necessary. And as the policy also provides the flexibility to hire somebody from outside to be a decision maker. There's obviously an expense issue involved, and there's a question of finding people who are familiar with colleges and universities and how they act. But those are really the major changes. Otherwise, the policy is very prescriptive in terms of how to go through each of these steps, from receiving a formal complaint to evaluating whether it should be a formal complaint, to conducting an investigation, to preparing an investigation report, to conducting a live hearing, to preparing a final report, to how an appeal is handled. It's in accordance with the regulations, again, which are very detailed, but we've tried to gear it towards how our colleges will be able to handle these. And it's really geared to be, again, very prescriptive for those involved. So I'll pause there and ask whether anybody has any questions on the sexual misconduct policy itself.
This is Emily. I have one question. On the training use and the development of the regional model, maybe more for what's our time turning around?
We've provided some training, online training to the Title IX coordinators already. We have now selected a law firm, which was the low qualified bidder, to provide some training that's going to be modulated. It's going to be available. It's going to be modules. It can be provided at one time, but it also can be then reviewed as needed at people's leisure and convenience, and in advance of having to actually to do this. Dr. Lemming might have a more specific time, but I believe we're trying to do that within the next 2 to 4 weeks.
That is correct.
Hey, Brian?
Yes.
What about events, like when we have competitions that we send students to, and I know that Will, has done TISL, where we send them to Nashville. They may not be associated with a class. They may be just an activity that's done. Some may be associated hard with an academic class. Are those areas that would fall under the new regs?
Potentially. What the regs say is that we have to make a case-by-case determination as to whether they are in the educational program and activity. So if it's a school-sponsored activity, for example, a chaperoned trip to Nashville to visit the state legislature, where the school has identified who can go on the trip and where folks are going to stay, and there's an allegation that happened, say, at the Doubletree Hotel in Nashville on a Saturday night, that is likely going to be considered within the context of the program activity, because the school will have had sufficient control both over the environment as well as over the respondent, assuming that he or she is the student. If it were a looser type of arrangement, then perhaps not. So the regs do call for a fact-specific determination, and that determination as to whether it occurred in the program or activity will be spelled out in the, if it's in a notice, if it's determined to be in the notice of, if it's determined to be within the program or activity, it will go into the notice of allegations as to why. If it's determined to not be within a program or activity, there will be an explanation in the notice of dismissal of a formal complaint as to why.
Okay.
I have a question. Given the fact that this process is much more legalistic in nature with opportunities, cross-examine, etc., to what extent, if any, is the process public? And the reason I'm asking is I would hate for our process to have a chilling effect on anyone coming forth with any concerns.
Yes, certainly if students, anytime a student is involved, it will, I mean, first of all, Regent Duckett, it is not any kind of meeting we would have to notice or anything we would have to advertise. Second of all, there are confidentiality protections under FERPA, the Family Educational Rights and Privacy Act, as you know, with respect to student records and student information. So that would, the general public is not involved. But even if no students were involved, and that is not the typical case for these, the hearing officer would have the control and the ability to say, you know, this is not a public process. Now, at the conclusion of the process, if there are no student records involved and there are no other exceptions, it would likely be, the determination would likely be a public record that could be asked for, as we occasionally get those asked for now.
Okay.
But as far as allowing people to come in and disrupt the hearing, that would not be. I don't anticipate that happening.
Okay, thanks.
Any other questions on that policy? All right, well, hearing none, I will then move on, and these should be much less to discuss. The next policy is the Equal Employment and Opportunity and Affirmative Action Policy, and there are really very few practical effects of these policy changes. Number one, we have to, the regs are now more detailed as to the appointment of a Title IX coordinator, so this policy now reflects how we appoint the Title IX coordinator and what we do. Second of all, as I said before, the Title IX coordinator in a sexual misconduct case is no longer permitted to be the one who investigates. There has to be that separation of functions. So I'll call this a conforming change so that our policies are consistent. And then the third change is really to see if, to make clear that the Title IX coordinator may or may not be the EEO affirmative action officer. On many of our campuses, that individual wears the same hats, but it's not a necessity that that person wear the same hats. But again, there's no prohibition against it either. The third policy is our sex discrimination, sexual harassment, or sexual misconduct policy. There are almost no changes here. Again, it's just to make sure that this policy is consistent with the revised sexual misconduct policy, should you approve it. And it really just reflects that the definitions in the sexual misconduct policy have changed, and that not all allegations of sexual harassment, which is, you know, not, which can mean a lot of different things to a lot of different people, will rise to the level of sexual misconduct, which is a defined term in our policy, and that definition is based on the Title IX regulations. The sex discrimination and sexual harassment policy does a few different things. It reflects increased record keeping obligations. There's now a 7-year requirement to keep records, and it applies to not only sexual misconduct investigations, but also to investigations under our existing policies. So we'll be beefing up our record keeping and making sure that the Title IX coordinators, or whoever else may be charged with that, but probably be the Title IX coordinator, keeps records on it. And it also says, this is the part where training materials will be posted on the website. So again, these are relatively technical changes, shouldn't be very controversial. They're just required to be in there. And then the final change is with respect to the development and operation of off-campus international education programs. The new regulations provide that for this formal complaint process to apply, it must be by a student or employee in the United States. So when we have foreign study programs, that's outside the jurisdiction, it's outside the scope of what Congress set for Title IX, according to the Department of Education, and I think that's probably right. So again, it wouldn't go through the formal complaint process, it would not be eligible to, but again, it's not like we would ignore it. So those are all relatively minor changes designed to make sure that our policies are consistent with each other and to comply with the parts of the Title IX regulations that don't apply exclusively to the sexual misconduct allegations. So I'll pause there again for any questions. And I can't tell, Regent Goldsmith, whether you have a new question or whether your hand is still up from the previous one.
I probably had a question that I forgot about. So.
Do you have those issues when you're teaching class that students, their elbows never get tired, I suppose, if all you have to do is press a button?
I teach a lot asynchronous for that reason.
Any further questions or comments for Brian? And again, I really appreciate the time and effort that he's put into this and that all of the board has put into this and in getting ready for this conversation.
Yeah.
If there are no questions, as I mentioned when we began this portion of our meeting, we can take up all 5 policies together, but we will need a motion to approve these revisions.
So moved.
Thank you. Who was that?
Miles.
Miles, thank you. And a second?
Second.
Thank you, Regent Duckett. Are there any further comments or any discussion? Hearing none, Madam Secretary, let's call the roll.
Thank you, Madam Chair. Regent Apple.
Aye.
Regent Burdine.
Aye.
Regent Duckett.
Aye.
Regent Gill, have you joined the call? Regent Goldsmith.
Aye.
Regent Green.
Aye.
Regent Hatch.
Aye.
And I believe Commissioner Hatcher has joined us.
Yes. Aye.
Thank you. Regent McEllier.
Aye.
Regent Prescott.
Aye.
Vice Chair Reynolds.
Aye.
Regent Shockey.
Aye.
Regent Garland.
Aye.
Regent Long.
Aye.
Thank you. And Regent White.
Aye.
Motion carries unanimously.
Very good. Thank you all. Thank you, Brian,
Thank
very
you.
much. Thank you. We have a second policy to take up today that is new in its nature, and this is with regard to infectious diseases. And Vice Chancellor Heidi Lemming is on the phone. Of course, she heads our student success efforts. Heidi, welcome. Hope you are doing well, and walk us through this, if you will.
Thank you. Good afternoon, everyone. Before you is a new policy that would require all of our colleges to develop their own institutional policies or use the TBR policy in regards to how they would respond to any infectious or communicable disease outbreaks that might occur. And of course, this is being prompted as a result of COVID. We did have several institutions that had something in place. We reviewed those, and then we also did a national search to identify best practices in policy and have tried to incorporate those items into this draft that you have before you today. The policy is intended to provide guidance as well as options for a campus to pursue related to not only how they communicate their responses to constituents at their institution, but also how they go about potentially requiring individuals to submit particular items to gain entry back onto the campus after they have had an infectious or communicable disease. So you'll see in the meat of the policy there several different options that are provided to our campuses in terms of procedures for how to respond to students, faculty, and staff. And so, that's the overview of why we decided that we needed to really have this right now, obviously, is to be consistent with all of our institutions and how we approach how we address the current situation, but also anything that might come up in the future. So happy to answer any questions that folks might have.
Questions for Dr. Lemming? Was well written, pretty straight up language, and obviously tailored to our times certainly, but applicable for the future as well. Mm-hmm. We do need a motion for approval of this policy if there are no questions of Dr. Lemming.
I move to approve.
Thank you, Regent Prescott. And a second?
Second.
Regent White, thank you, sir. And one last call for any further comments or questions. Hearing none, thanks to all for the good work that's gone into this. And Sanja, if you would call the roll, please.
Thank you. Regent Apple?
Aye.
Regent Burdine?
Aye.
Regent Duckett?
Aye.
Regent Goldsmith?
Aye.
Regent Green?
Aye.
Thank you. Regent Hatch?
Aye.
Commissioner Hatcher?
Aye.
Regent McEllier?
Aye.
Regent Prescott?
Aye.
Vice Chair Reynolds?
Aye.
Regent Shockey?
Aye.
Regent Varlin?
Aye.
Regent Womp?
Aye.
Regent White?
Aye.
Motion carries.
Very good. Thank you all. As we adjourn this business portion of the meeting, I do want to say to the team again, thank you for everything you've done over these past few months and that you're about to redo as we officially start a new academic year. I love the notion that we, in fact, never close. That is an absolute point of pride. Chancellor, other than telling our folks on the live stream, we will see them at our quarterly meeting, September 22, 23. Do you have any further announcements for the afternoon?
Not for this portion of the meeting. Thank you.
Thank you very much. At this time, then, board members remain on. We are going to have an interesting discussion with Derek Young next. And if there are no objections, we will adjourn today's meeting. Thank you all very much.